Vice-Chancellor, Dean of the Faculty of Law, Court of Final Appeal judges, distinguished guests, ladies and gentlemen. It's a great pleasure to introduce the speaker for this evening, Lord David Neuberger, President of the UK Supreme Court. The faculty was very fortunate yesterday. Lord Neuberger spent most of the afternoon yesterday taking part in a faculty symposium on contract law, tort law, restitution, equity. Lord Neuberger has kindly agreed to deliver this lecture this evening on access to justice, the Court of Final Appeal under one country, two systems. I'm not going to delay the pleasure of listening to Lord Neuberger this evening any further. We look forward to Lord Neuberger's talk. After the talk, there will be question and answer. Ladies and gentlemen, Lord Neuberger.
Vice-Chancellor, Dean of Faculty of Law, fellow judges, ladies and gentlemen. It's a great pleasure to be here at the University of Hong Kong. Somewhat awe-inspiring to be speaking in such a large hall, and thank you all for coming. The unique one country, two systems arrangement proposed by Deng Xiaoping in the early 1980s and formalized in the 1984 Sino-British Joint Declaration has now been in place in Hong Kong for 20 years. Perhaps particularly from the perspective of a judge, not least a non-permanent judge of the Hong Kong Court of Final Appeal, this unique arrangement is not only interesting in itself, but it also casts a slightly unusual shaft of light on the close to universal, if somewhat more elusive, topic of the rule of law. I refer to the rule of law as being close to universal because I think that virtually everybody would agree that the rule of law is fundamental to any civilized society, whatever its location in terms of time or place. I refer to it as elusive because there is considerable room for disagreement as to what the rule of law actually means or how far it goes. That's unsurprising. It's a commonly used expression with a variety of potential different meanings, and different countries have different traditions and different experiences. Indeed, what is taken for granted as part of the rule of law in one country today may well have been thought to be revolutionary or unrealistic in the same country centuries or even sometimes decades ago. Nonetheless, I'd suggest that in the 21st century, the rule of law has a virtually universal basic minimum set of requirements. In a nutshell, that set of requirements can be encapsulated in the proposition that a society must be governed by laws which are first properly enacted, secondly clearly expressed, thirdly publicly accessible, fourthly generally observed, and fifthly genuinely enforceable. The laws by which people are expected to live their personal and commercial lives must be created in a coherent and proper way. Otherwise, laws would be likely to be arbitrary and almost certain to be regarded as arbitrary. Such laws must also be written in a way that they can be understood, and once created, they must be available to be read by everybody. It cannot be consistent with the rule of law to have laws which are incomprehensible or inaccessible. It would mean that people couldn't find out what their legal rights or legal duties were. Now, we live in a world which is technologically, commercially, and socially increasingly complex and increasingly fast-moving. This renders it ever more challenging to draft laws in a coherent way and in clear terms. And the fast pace of change also means that laws have to be frequently amended, which makes accessibility more difficult to achieve. The suggestion that the rule of law requires laws which are generally observed is justifiable essentially for two connected reasons. First, if a law is not generally observed, then that brings the rule of law into disrepute. Secondly, particularly in a democratic society, but also I think in a non-democratic society, the long-term survival of a government system depends on some sort of implicit mutual understanding between the governing and the governed. If those responsible for making laws create a law which is not generally observed, then that's a good indication that this mutual understanding, and with it the basic compact on which society depends, is being undermined. But having briefly discussed the first four ingredients of the rule of law, I turn to the fifth of the five requirements, enforceability, because it's that ingredient which I'm primarily concerned with this evening. Enforceability involves people having an access to an institution, almost invariably a court or tribunal, to enable them to enforce their rights and to defend themselves. If rights, whether against other people or against the state, are not in practice enforceable, that's as bad as having no rights at all. Indeed, it can fairly be said that it's better to give people no rights than to give them rights which they cannot enforce. A government that gives people no rights is at least not hypocritical or dishonest, whereas a government which gives people rights on paper without the ability to enforce them or have the protection of them makes a mockery of the rule of law. Of course, enforceability not only requires that rights granted to people are realizable, it also requires effective protection granted to people is also recognizable, most obviously to those being pursued by the state, such as alleged criminals, who are entitled to enjoy the reality of principles such as the presumption of innocence. And accessibility involves ensuring that people can actually get to court, but it also involves ensuring that they can get legal advice ahead of going to court. I've already referred to the fact that modern legislation is complex, and it's not sensibly possible to expect non-lawyers to appreciate their legal rights and obligations without being able to consult lawyers. It follows from this that the rule of law requires people to have access to lawyers who can advise them competently and impartially, and it requires the honest, fair, efficient and open dispensation of justice in the courts. Access to lawyers for legal advice and representation presents a problem in many countries where lawyers cost a disproportionate amount in relation to modest cases. At least in the United Kingdom, this is due to a number of factors. Lawyers having high overheads, lawyers having high professional standards and therefore attracting expensive people, and disproportionately elaborate legal procedures. We should watch out. If ordinary people are denied affordable legal advice and legal representation, they are not being afforded access to justice, and the rule of law is being undermined. Governments, judges and lawyers all have duties to ensure access to justice. Governments by ensuring that courts and judges are available and that, subject to reasonableness, bearing in mind other demands on government funds, that people can afford to get access to legal advice and representation. And judges and lawyers have to do their best to ensure that legal advice is provided and legal proceedings are conducted as cost-effectively and proportionately as possible. It's easy to say, but certainly in the UK, and also I think in Hong Kong, it's difficult to achieve in an increasingly complex world. But the very fact that access to justice represents such a challenge serves to underline why it's important that it's properly addressed. And I notice that the Basic Law, of course, has a specific provision dealing with access to justice. And at the other end of the justice process, it's no good enabling people to go to court and have their rights determined if the court's decisions are not then put into effect. Again, it would make a mockery of the rule of law to give people the right to go to court, to vindicate their rights or identify their duties, if the order of the court was no more than words written on a piece of paper with no practical effect. So I turn to the courts themselves and what's required of the judges. I suggest there's no hope for the rule of law unless we have judges who are not only accessible, but who are honest, impartial and competent, and who are seen to be honest, impartial and competent. It's self-evident that if judges are dishonest, if the judiciary can be bribed or suborned, the rule of law will be fatally undermined. If judges break the law, what possible hope is there that anyone else will bother to observe it? Similarly, competence and impartiality are essential requirements of a judge. An incompetent or unfair judge is almost as much of a contradiction in terms as a dishonest judge. Competence is a prerequisite for judicial office. So is impartiality, which involves judges making sure that the law is applied equally and fairly to all litigants, irrespective of their means, gender, age, and other characteristics, in particular their social, political, or economic status. It's why justice is traditionally portrayed in Western art as blind. These judicial qualities are reflected by the fact that in both England and in Hong Kong, when he or she first takes office, a judge swears a solemn oath to do right to all manner of people after the laws and usages of this realm, without fear or favour, affection or ill will. In many countries, including the United Kingdom, judicial diversity is seen as a very important factor as well. While it's not as inherently fundamental as honesty, competence and fairness, I suggest that diversity is indeed an important factor. An undiverse judiciary is indicative of unfairness, which is a pretty serious complaint in connection with a profession concerned with fairness. Lack of diversity also suggests that some of the best potential judges are missing out, and that's obviously of concern as well. And in a diverse society, albeit within limits, litigants justifiably expect a bench which roughly reflects the population. Of course, in a system such as that which prevails in the United Kingdom and in Hong Kong, where judges are almost exclusively selected from the legal profession, lack of diversity in the profession will almost inevitably result in a lack of diversity in the judiciary. And if there is serious lack of diversity, it's not merely the judges and those who select the judges who should be concerned. Apart from honesty, competence, fairness and diversity, in countries which may be described as liberal democracies, like the great majority of European and Commonwealth countries and the United States, judges have an additional important feature, namely that of judicial independence. And that, of course, applies in Hong Kong, where it's referred to in no fewer than 3 articles of the Basic Law. Although judicial independence may be confused with, although it may sound like judicial impartiality, judicial independence is very different. Judicial impartiality is an attribute which an individual judge should have in each case. It's embodied in the notion that judges administer justice with lack of bias. So it's a judicial attribute which applies to judges on an individual basis in every case. By contrast, judicial independence is at least as much an institutional judicial attribute as it is an individual judicial attribute. In a system which has developed in the countries I've mentioned, the basic constitutional arrangement is seen as involving 3 branches of the state, each with different complementary functions, which, at the risk of verging on oversimplification, can be fairly simply expressed. There's the legislature, which makes and develops the law. There's the executive, which carries out and enforces the law. And there's the judiciary, the judges who interpret and give effect to the law, and at least in our common law systems, sometimes develop the law as well. Under that arrangement, the rule of law requires the 3 branches of government to be generally independent of each other. Those who make the law should not be involved with interpreting it or carrying it out. Those who carry the law out should not make it or interpret it. And those who interpret the law should not be concerned with legislating. Independence for the judiciary means in particular that neither the legislature nor the executive should be able either to interfere with or influence judicial making, other of course than in legal argument in court, or to remove judges from office. Judicial independence has long been regarded in countries with traditions such as those in the UK not only as particularly precious, but also as particularly precarious. The precariousness was very well explained by Alexander Hamilton, one of the founding fathers of the United States. He wrote in one of the famous Federalist Papers, which did so much to formulate the basis of the US Constitution, that the judiciary is beyond comparison the weakest of the three departments of power, having, as he graphically put it, no influence over either sword or purse. Accordingly, as he went on to say, all possible care is requisite to enable the judiciary to defend itself against attacks, and in particular from the executive or the legislature. At least in a democratic society, the legislature is often seen to have the greatest legitimacy of the three branches of government, because unlike the executive or the judiciary, its members are democratically elected. However, even to those who believe passionately in democracy, that very fact means that it should respect the independence of the judiciary. Democracy is not faultless. It can lead to the tyranny of the majority. Indeed, in extreme cases, democracy can lead to the election of vicious tyrants or worse, as it did in both Italy and Germany in the 20th century. Furthermore, on more normal circumstances, politicians are frequently driven to make decisions which are based on expediency, and perhaps particularly in a democratic system, to make decisions which are based on relatively short-term electoral considerations, or indeed duck making decisions that should be made. That's not meant to be a criticism of politicians. It's inherent in the nature of their role. The courts can therefore usefully act as a brake on political calculation and short-termism, and sometimes when decisions need to be made, the judges can make them. Furthermore, the very fact that the judges do not have to worry about being re-elected or losing their jobs mean that they can and should sometimes make the difficult, unpopular decisions, which are understandably very difficult for politicians. There are occasions when judges have a duty to make a policy decision because legislation requires them to do so, in which case the judge is simply carrying out the democratic will as expressed by the legislature. But there are also cases where, because of the legislature's failure to act and resolve a policy issue, judges may feel that it's incumbent on them to resolve the issue, to fill the gap. And in such cases, the judges have a duty to do it. But it is a power which judges should exercise diffidently and cautiously. The UK Supreme Court adopted just such an attitude when it had to decide whether the statutory criminalization of assisting a suicide in all circumstances violated the human rights of people who were paralyzed in some pain, fully in command of their faculties, and firmly wished to die. Although some of my colleagues thought we should decide that their human rights were infringed, and others of my colleagues thought it was not a matter for the court at all, the prevalent view of the court was that Parliament should consider the issue more carefully, and if it did not change the law, we, the judges, should look at it again in the light of Parliament's deliberations. As for dealing with the executive, a judge has no more important function than to protect citizens against abuses of power by the executive. The executive is an increasingly mighty executive branch of government in most countries, and most of the abuses of power, the great majority I hope, do not amount to anything involving intentionality or dishonesty or even malice, but the power of the executive has to be curbed, has to be guarded by the judges. So the separation of powers which is to be found in the governments of what I've called liberal democracies is based on the perceived desirability of avoiding the concentration of power in the hands of any one group. And that's achieved through the means of checks and balances between the three arms of government. However, even countries governed according to a liberal democratic system with separation of powers and an independent judiciary have significant differences in the way in which they function. Most such countries have a written constitution, which the court can enforce even over the heads of the legislature. Thus, as we all know, the US Supreme Court can strike down as unconstitutional legislation even which has been passed by a democratically elected Senate, a democratically elected House of Representatives, and approved by a democratically elected President. The German Constitutional Court can also effectively strike down primary legislation if they consider it unconstitutional. And of course, the same is true of the Hong Kong court and judges who, as I've said, have their independence emphasized in 3 of the articles of the Basic Law. But in the United Kingdom, where parliamentary sovereignty applies, judges have no right or power to overrule or even to refuse to apply a statute enacted by the House of Commons, the House of Lords, and signed into law by the Queen. The furthest UK judges can go is to declare that a statute infringes human rights. And when that happens, Parliament has, with one exception, changed the law. I think such different constitutional arrangements largely represent different traditions and experiences. Over the past 200 years, the UK has enjoyed democracy without any tyranny, whereas by contrast, within the past century, the German people saw Hitler come to power as a result of democratic elections. So they have, as it were, less confidence in democracy than maybe the UK does. The system of government which I've been discussing, and which involves judicial independence, is currently very common, but of course it's not universal. It doesn't exist in China, where the system is more monolithic or unitary. The party embraces all aspects of government, including the judiciary. While that means that judges in the PRC do not have institutional independence in the same way as in a liberal democracy, it does not detract from the fact that just as judges in liberal democracies are expected to be honest, competent, and impartial, so are judges in China. Now, I can't claim to any expertise when it comes to the detailed working of the Chinese system of justice, let alone to the finer details of Chinese culture. What I can say is that bearing in mind its political, cultural, and economic experiences over the past 1,000 years, and more particularly over the past century, it's unsurprising that China has evolved a somewhat different system of government from that of Western Europe, the Commonwealth, and the United States. As a judge, it is not for me to assess, let alone to say, how China can or should be governed. But as an intelligent, I hope anyway, as an intelligent and interested observer, I can properly say that it's easy to appreciate how it can be argued that there is a need for a greater degree of central control in the governance of China than in many other countries. Where I can speak with more authority and justification is in relation to what is now part of China, namely Hong Kong. Its system of government, like that of any country, is, as I've mentioned, a product of its economic and cultural history. For nearly 100 years up to 1997, Hong Kong had been a colony of the United Kingdom, with no democracy, but with its own independent judiciary, albeit that the final appeal court was physically in the United Kingdom, with largely UK judges. And then in 1997, Hong Kong reverted to China, but instead of the monolithic party-based governmental system which applies in the rest of China, it has a system which generally accords with that of liberal democracies. Uniquely, the PRC has introduced and maintained in Hong Kong, and of course Macau, the one country, two systems arrangement. Now, I'm of course aware that there's disquiet in some quarters about aspects of the way this unique system works, and in particular, Beijing's right not to appoint a democratically elected candidate under the Basic Law, Beijing's right to interpret the Basic Law bindingly on the Hong Kong courts, and some actions in Hong Kong allegedly taken by Beijing. I'll turn to them in due course, but it's not my primary concern for this evening, nor should they be the primary concern of a judge, at any rate when talking publicly out of court. I mentioned earlier that judges in liberal democracies making policy decisions in court should proceed with caution and diffidence, because policy decisions are primarily for the legislature. Even more, judges should be careful what they say in public out of court. 50 years ago in the UK, judges hardly ever spoke publicly, and when they did, their talks were normally limited to technical legal issues. The world is now a very different place. Judges, or at least senior judges, are expected to speak more, and it's right and proper that we explain to the public what we do, how we do it, and why we do it. And as guardians of the rule of law, we sometimes have a duty to speak out more widely. But whenever we speak publicly, we have to remember the separation of powers. Just as we expect politicians and civil servants to keep out of the judicial area, so we should respect their territory and not pontificate on issues which are not properly for the judges. Having said that, unlike most territorial boundaries, the boundaries between the three branches of government are not precise. They can be porous, and there are undoubtedly areas of overlap, but none of that undermines the point that judges must be careful not to stray outside their prescribed constitutional area when speaking in public. So it's right and proper that when discussing the rule of law in Hong Kong, I focus on the role of the judges, and in particular the role of the court in which I sit as a non-permanent judge, the Hong Kong Court of Final Appeal. In that connection, I have read some suggestions that at least when it comes to some decisions, the Hong Kong judges are not independent, and that they're somehow lent on by the authorities in Beijing, or they are not impartial in that they are somehow anxious to please the authorities in Beijing. I can say from my own direct experience as a judge that the permanent judges of the Hong Kong Court of Final Appeal are as individually and as institutionally independent and as personally impartial as their equivalents in the United Kingdom, the justices of the UK Supreme Court. While I cannot speak from first-hand direct experience in court, I have every reason to believe that this is equally true of the judges in the other courts of Hong Kong. I have not seen or heard anything to suggest they are not as impartial or as independent, and this is demonstrated by their reputations, their apparent character on meeting them, and the contents of their judgments. Again, my view is based on much the same evidence as leads me to that conclusion in relation to the judges in England, Scotland, Wales, and Northern Ireland. If I had any serious concerns about judicial independence or judicial impartiality in Hong Kong, I would not be sitting in the Hong Kong Court of Final Appeal. And the same is, I am sure, true of the other common law jurisdiction non-permanent judges. They include a number of former and present members of the UK Supreme Court, a number of former members of the Australian High Court or state Supreme Courts, and I'm sure they have the same view as I do. Coal mining can be a dangerous exercise, but in the past it was more dangerous than it is today because of the escape of poisonous but colourless and odourless gases, in particular carbon monoxide, which regularly used to kill miners. About 100 years ago, someone came up with the idea of coal miners taking a cage with a little bird, normally a canary, down the mine, on the basis that the canary would be visibly affected by any poisonous gas before the gas could have any fatal effect on human beings. The ingenious idea worked. Miners would keep an eye on the canary, and if it started to droop, they would vacate the mine and save their lives. On a previous occasion, I've suggested that the foreign non-permanent judges are the canaries in the Court of Final Appeal mine. So long as we are happy to serve on the Court of Final Appeal, I think you can safely assume that all is well with judicial independence and impartiality in Hong Kong. But if we start to leave because of concerns about judicial independence or impartiality, that would represent a serious alarm call. It was recently pointed out to me that this suggestion may be a bit insulting to the full-time judges of the Court of Final Appeal, as they should be equally unprepared to be a member of a judiciary which was not genuinely independent. That's a fair point, although it's also fair to say that the permanent judges do not have the advantage which the foreign non-permanent judges have of being able to see the Hong Kong judiciary objectively from the outside, as well as having the advantage of knowing how things work inside from experience. It's perhaps right to go a little further when discussing the non-permanent judges and record my admiration for the introduction of the innovative idea of having a foreign judge sitting in a top court. I do not say that simply because I greatly enjoy and learn much from my judicial visits to Hong Kong, but as Justice Fock has explained in a recent lecture last year in Australia, there are a number of benefits from the arrangement. In addition to reinforcing the credibility of the Hong Kong judiciary, as I've already described, the non-permanent judges bring considerable general judicial experience, as well as often bringing specialist legal experience to the Court of Final Appeal. And in an increasingly global world, the non-permanent judges help ensure that Hong Kong law benefits from developments elsewhere in the common law world. It's interesting that Singapore has taken up the idea of foreign judges sitting in its courts. So a number of judges or former judges from the UK and other countries now sit in the Singapore International Commercial Court. Of course, because the CFA is a national court, it is quite rightly provided that only one foreign non-permanent judge can ever sit on a particular appeal. So the national Hong Kong judges are always in a very substantial majority. Nonetheless, the NPJs do much more than act as a visible guarantee of the independence and impartiality of the Hong Kong judiciary. Despite this confidence in judicial independence and judicial impartiality in Hong Kong, I accept that there are allegations in the media that judicial independence and judicial impartiality are being eroded, as I've mentioned. Such suggestions arise from time to time in many jurisdictions, particularly when cases with a political flavour come before the courts. Every judge in any jurisdiction will have had to face an allegation of bias or corruption from a litigant who has lost a case. If you're convinced of the rightness of your case and it's then rejected by the judge, it's very tempting to believe that the judge must have been got at in some way. There's no other explanation as to why you lost. Similarly, a politically committed person who believes that a judge has wrongly decided a case with some sort of political implications finds it very easy to conclude that the judge must have been lent on to explain why he decided the case the way he did. In politics, feelings often run high, and neither intemperate thoughts nor intemperate language is unusual. At any rate, in the legal traditions of Hong Kong, and indeed the United Kingdom, intemperate language in the law is discouraged, and it is indeed very rare, or so I like to think. It's unfortunate if public figures and journalists see fit to allege that judicial independence is being eroded without any evidence, save a judicial decision or two with which they disagree. It's unfortunate not merely because it's unfair, it's also unfortunate because it risks undermining the judiciary, both in the sense of reducing public confidence in the judiciary and in the sense of making the judiciary a less attractive career for able lawyers. Public confidence in the judges is vital to the rule of law. As well as being done, justice must be seen to be done. Getting able lawyers to become judges is essential if we are to have a good quality judiciary, and that too is vital for the rule of law. The United Kingdom judiciary suffered from misconceived attacks in the media and from a few politicians towards the end of last year in connection with the Brexit or Miller case. As you may know, a UK-wide referendum in June 2016 produced a majority in favour of leaving the European Union. In order to give effect to this, the UK had to give a formal notice to the EU. The government made it clear that it intended to give the notice without seeking the formal sanction of Parliament. The question was raised by Mrs. Miller, an interested citizen, whether it would be lawful to serve this notice without formal legislative authority through a statute. The case came before 3 judges in the Divisional Court of the English High Court. They decided it would not be lawful, that formal parliamentary sanction had to be obtained. This produced something of a furore. In what was already a highly charged political atmosphere, the case was seen as a sort of proxy war between those who wanted to leave the EU and those who wanted to remain. The newspaper, the Daily Mail, ran a shameful front page with headshots of the 3 judges and in large letters underneath the words "enemies of the people." It was not only the only national newspaper to damage the reputation of the newspaper industry in this way and to seek to undermine the judges in this way, but it was the worst. A few politicians who should have known better joined in the attack, and members of the government regrettably failed in their duty to stand up for the judges. This sorry story shows that misconceived attacks on the judges can happen anywhere and are particularly likely to happen in politically charged atmospheres. Of course, it can fairly be said that any individual or group of individuals will be prone to making unjustified attacks in a society where freedom of expression is respected and where and it can be said the judiciary can be no exception. So too, it can fairly be said that judges should be robust enough to rise above unjustified attacks. But those arguments fail to address the real concerns about such unjustified attacks on the judges, namely that they undermine the rule of law. Like almost every right, freedom of expression involves responsibilities as well as rights, and there is real responsibility on every citizen, but especially the media and politicians, not to undermine the rule of law. Just as judges have the right to expect that the judiciary will not be subjected to baseless attacks, so do we have the duty to explain, as well as we properly can, what we actually do and how and why we do it. Much is made of the importance of open justice, and rightly so. If judges hear cases in courts open to the public and give reasons for their decision which are publicly available, that should go a long way to satisfying members of the public that we're performing our duties properly, and in particular that we're conducting our hearings and making our decisions in accordance with the law and in an independent and impartial way. The UK Supreme Court has gone somewhat further. In relation to hearing, all appeals are filmed and the recordings are live streamed on the court's website, and copies are available for anyone interested for a year, or even later if asked for. When the court gives judgment, not only are paper copies available at court and electronic copies of the judgment available on the website, but the court publishes two-page summaries with the judgment so that journalists and other lawyers can quickly see what the case decides without having to plough through judgments which are often long, detailed and technical. I've commented on the fact before that it's quite depressing for a judge to have to feel that he's losing the will to live when reading a judgment. It's particularly depressing when he discovers it's one of his own. But we also arranged for the court to, the judge who gave the leading judgment in the case, to read out a very brief, even briefer, summary of the decision when it's, and that is broadcast. I think that the fact that the Miller case hearing in the Court of Appeal was streamed and publicly watchable from start to finish, that a summary of the court's decision was broadcast when the judgment was given, and the reasons were summarized on 2.5 pages, helped ensure a much more appropriate media and political reaction to our decision, even though we upheld the divisional court. Watching the hearing made people realize that the case involved serious constitutional issues, which were being seriously considered and discussed by the lawyers and judges. The written and oral summaries of the decision not only enable people to understand what the issues were, how we resolved them, but also what our reasons were. It also enabled the court to explain the nature and the effect of the decision succinctly to journalists who were anxious to get their reports out as quickly as possible. It's only fair that I accept that there were a number of other factors which helped ensure that the reception of our decision was much more sensible than the reception of the divisional court decision. I think the media appreciated they'd gone over the top previously. I think there was a slight cooling off in the political atmosphere. And the fact that 3 of the 11 justices in the Supreme Court who heard the case disagreed and were in favor of the government meant that the press could find 3 heroes rather than just having villains. Now, it's not for me to say whether filming proceedings in the CFA would be appropriate in principle or proportionate in terms of costs. It's worked in the UK Supreme Court, it's being considered in our Court of Appeal, but not for first instance trials where the presence of cameras could be unfair on witnesses and on jurors, and indeed might encourage some witnesses to play to the gallery. It's fair to say that at least on the face of it, cameras in court can be seen as something of a logical extension to open justice, and open justice is a fundamental aspect of the rule of law. Open justice, and indeed judicial independence, like all the other aspects of the rule of law I've mentioned, are essentially procedural in nature. They're not concerned with the actual substance of the laws. That's why the version of the rule of law I've so far been discussing is sometimes known as the narrow or thin rule of law, or sometimes rule by law. The broad or thick version of the rule of law goes much wider and includes substantive principles of law. To many judges and practicing lawyers in the United Kingdom, this broader version of the rule of law is most famously discussed and explained in a shortish book, The Rule of Law, written by Lord Bingham, the sadly deceased former senior law lord, which was published 7 years ago. This broader version of the rule of law includes many of the fundamental rights which are to be found in documents such as the United Nations Universal Declaration of Human Rights, the Council of Europe's Convention on Human Rights, and Articles 25 and following of the Basic Law, and indeed many of the constitutions of the world. The broader version of the rule of law thus includes rights and freedoms such as freedom from torture, freedom of expression, arbitrary imprisonment, respect for family life, privacy, freedom of religion, to marry, discrimination, to name but some of the more better known ones. To a person, particularly a person with legal training, brought up and living in a liberal democracy today, it's hard to quarrel with the notion that these rights and freedoms are an inherent and very important part of the fabric of our society. But it's right to refer back to a point I briefly touched on at the beginning of this talk, namely that unlike the fundamental ingredients of the narrow rule of law, which are close to universal geographically and to some extent temporally, what are regarded as the fundamental ingredients of the broader rule of law, as in the Declaration of the European Convention on Human Rights, cannot mostly be said to be timeless or universal. 500 years ago, in the England of King Henry VIII, hardly any of the rights which are taken for granted today in the UK, such as freedom of expression, freedom of religion, freedom to marry, freedom from discrimination, or even freedom from torture, would have been recognized by the great majority of educated and civilized people. And in many countries in the Middle East and Africa, some of these rights and some important aspects of other rights would not be recognized today by the majority of the population. I can be described as being a moral relativist, and depending on your definition of the expression, I may well be. But it does not seem to me that while I personally believe very strongly, it does seem to me that while I personally believe very strongly in the existence and importance of these sorts of rights and freedoms, they are not necessarily timeless or universal. And with one or two exceptions, they are not even absolute. It's recognized in the very terms in which they're expressed in some cases. Freedom of expression or respect for privacy are not absolute. Even apparently absolute rights like freedom of religion or freedom to marry have obvious limits. You can't kill someone simply because your religion requires it. You can't marry a child or someone who's already married. Indeed, there is an arguable, if hotly contested, view that even torture may be justified in very extreme and very exceptional circumstances. Right from its inception as a special administrative region of the PRC, Hong Kong has had the broader version of the rule of law expressly included as part of its law through the Basic Law and the Hong Kong Bill of Rights. The position in the United Kingdom is slightly different. The UK is almost unique among the liberal democratic countries of the world in not having a written coherent constitution. Almost unique because New Zealand and Israel don't either. So there appears to be a powerful case for saying that it's only when Parliament enacted the Human Rights Act in 1998 and effectively incorporated the Human Rights Convention into domestic law so that UK judges could give effect to it, we had the broader version rule of law in the UK, a year after Hong Kong got it. But because much of the UK's constitution is unwritten and based on convention, the position's a bit more murky. Many English political philosophers and legal thinkers like to say that the English were really the originators of human rights. Certainly, most of the objections which are raised in the UK to the Human Rights Act are and were ultimately founded on not the contents of the Convention, but the fact that the Convention is European. That's why proposals for the repeal of the Human Rights Act are normally accompanied with an assurance from the would-be repealers that the Human Rights Act would be replaced by a so-called British Bill of Rights. Now, none of this is really centrally relevant to what I have to say, but what is relevant for my talk this evening is that the UK, which has always been my home, sees itself as being in the vanguard of the movement for fundamental rights. While I may be a fundamental rights relativist in objective terms, I would be profoundly uncomfortable about living in a society which did not, at least to a very substantial extent, unhesitatingly subscribe to the broader version of the rule of law. And I'd simply be unprepared to be a judge in a society which did not subscribe to the broader version of the rule of law. But having said that, it's right to acknowledge that virtually nobody, however patriotic, can realistically expect to agree with every law of the country in which they live. And if people could only become judges if they agreed with every law they had to administer, hardly any country would have a judge. More broadly, particularly in today's highly legislated and regulated world, there will almost inevitably be aspects of lawful legislative and executive decisions or actions with which a judge will be unhappy, sometimes even decisions or actions which have a substantial impact on the rule of law. But that does not mean that such a judge should step down in the face of having to administer such legislation. Thus, probably almost all judges in England and Wales strongly disagreed with and regretted the UK government's decision at the end of the last century drastically to curtail civil legal aid and replace it with a highly questionable new system, which undoubtedly impinged detrimentally on access to justice. But no judge resigned as a result of the passing of the ironically named Access to Justice Act 1999, nor should they have done so. The exigencies and realities of modern political and economic life are such that the lawmakers and members of the executive have to make compromises, and it's inevitable not merely that these compromises will not satisfy everyone, but that they will sometimes turn out to be unsatisfactory. Indeed, often the art is to find the least unsatisfactory solution to a problem. Accordingly, it's unrealistic for anyone, including a judge, to expect the system under which they live and operate to be satisfactory or even justifiable in all respects. Having said that, of course, a point may come where the laws or executive actions are such that a judge feels that he or she can no longer, in all conscience, continue in office, that it's no longer appropriate to be part of the system. To that extent, it's right for a judge who strongly believes in the existence and maintenance of fundamental rights to be concerned about the maintenance of the rule of law in the broader sense, in the place where he or she is administering justice. It's almost inevitable that there will be aspects of the law or executive actions in Hong Kong about which I'm concerned, just as there have been and are aspects of the law or executive actions in the United Kingdom about which I'm concerned. But just as there was no question of my concerns causing me to resign as a UK judge, so there is no question of my present concerns causing me to resign as a Hong Kong judge. I've concentrated in this talk on the role of the judiciary, but not least because I'm speaking at a university. It would be wrong to end without paying tribute to the contributions of legal academics to the rule of law. The importance of the role of academic lawyers in considering issues about the rule of law, in discussing and criticizing judicial decisions, and in teaching future generations of lawyers cannot be overestimated. There are inevitably differences of approach between judges who make decisions with practical effect based on focused adversarial arguments, and academics who can take a more broad, more in-depth, and less fact-based view. But that reinforces the fact that the two groups should listen to each other and learn from each other. I've discussed in a previous lecture the historic reluctance of judges in the UK in the past to take account of the writings of academic lawyers, and how this has fortunately changed over the past 40 years. The cross-fertilization between judges and academics is as valuable when it comes to the rule of law as it is on any other legal issue. And in a place as vibrant as Hong Kong, it's particularly valuable. Thank you all very much indeed.
Thank you very much, Lord Neuberger. Lord Neuberger has kindly agreed to take a few questions. Yes, the person with the green shirt. If you just wait one moment, a microphone will be brought to you.
Thank you. Lord Neuberger, I just wanted to ask, so my name's Hugh, I'm an exchange student from the UK, I'm at Durham University. I just wanted to ask in relation to the access to justice point you made and the decline in civil aid being given, legal aid being given to people in need, and the fact that whether you had any possible ideas about how we would solve the current crisis, about the reason why lawyers are so expensive at the moment because of all the rising tuition fees and the fact that it's even harder to become a lawyer and then you have to pay those off and then make some money on the side. The fact that legal aid is going down, I was just wondering if you had any thoughts about how our society could address those issues.
Thank you very much.
I think that you put your finger on part of the problem, partly because the UK, like Hong Kong, has a very successful commercial, legal and general services industry. It attracts good people, and if you don't pay lawyers reasonably well, they will go into other careers. Partly because lawyers can charge quite well, they do. That's human nature. As a result, legal services have become expensive. I think that there are, as I said, I think that it's up to the government, the judges and the lawyers to try and deal with this. The problem arises, and it's inherent in a capitalist system, that with ordinary people who have small legal problems in terms of money. And I think that part of the solution lies in government making money available for legal services. And one has to accept that there are other demands on government money. You can't expect them to sign a blank check. I think that we had a much better system in the United Kingdom before 1999. I think there was one imaginative solution which we've only recently developed in the UK, which might make the government more prepared to give legal aid, which is to up damages, in some cases, general damages, by 10%, and then say, if you're legally aided, not merely, and you win your case, not merely will the government get the costs back through an order for costs in your favor, but they will get the 10% of the damages by which the damages have been increased. It's a sort of tax of some sort on unsuccessful defendants, but it's been introduced in the UK through the judges in 2011, and I think it's worked quite well. I think the other factor one has to consider is proportionality, and this is where the judges and lawyers come into it. I think we have to accept that our common law system is prone to give us something of a Rolls-Royce treatment in terms of items such as disclosure of documents, discovery, and cross-examination, which tends to make our proceedings much more expensive than the civil law system proceedings. And I think we should be looking at ways of providing quick resolution, what I've called before quick and dirty resolution of cases. It may be less perfect justice, but it enables cases to be fought at a cost which is proportionate to what's involved. I think that in England and Wales they're starting to do that, and one of the things that's being done is to try and see whether disputes can be settled online rather than with people having to turn up anywhere. It may be dangerous, but we've looked at eBay, where disputes are regularly settled very quickly and cheaply online. And while, of course, private dispute resolution cannot be equated to public dispute resolution. There are, as always, things that the public system can learn from the private system and vice versa. But to pretend I've got a magic bullet of an answer to your question would be quite wrong.
Other questions? Yes, the person in white on the left side of the main gallery.
Drawing on the last point that you made about basically technology and the future of the law, I just want to ask about your views on Richard Susskind's work, because I know you work closely with him, but in a speech that you gave not so long ago, in July, I think, you said that it is no longer fanciful to think that artificial intelligence will be able to do the job of lawyers and judges better than humans. I use my words carefully because I'm not saying it will happen, merely that it is not fanciful to think that it will happen. So it appears you're still a bit guarded in your views. Could you explain that? And
yes, you're absolutely right. I was hedging my bets, and I am not ashamed to do so. It's clear if you listen to discussions among experts, people who know far more about AI, about artificial intelligence than I do, that there is quite a division of opinion between them as to quite how far artificial intelligence can go. Certainly 10 years ago, we all thought that computers and artificial intelligence would be able to do the more obvious routine work, and we've all seen how it works in terms of searching for documents in discovery by using specific words, search words, or going through electronic documents. And no doubt, I suspect it's been taken a good deal further than it was when I last considered it as a trial judge, when it was in its infancy. But what we are seeing, as we see artificial intelligence beat the world champion not merely in chess, but in Go, as we see artificial intelligence beat champions in quiz shows, and as we read about, I think the two case studies I've looked at were using artificial intelligence to predict the outcome of patent cases in the United States, where I think they got something about 87% right, and using artificial intelligence to do something which I would find particularly difficult, to guess the outcome of results in the European Court of Human Rights. I think it got a figure close. It wasn't as high as 87%. But if these, and I must say, as far as I'm concerned, they are largely anecdotal, but if these sort of stories are right, you're getting to the position, if the logical analysis, as I see it, is if, and it's a big if, these stories are right and reliable and representative. If artificial intelligence is as good as the average top lawyer at predicting the outcome of cases in courts, then it should be as good as the top lawyer at advising people. And logically, I have some difficulty with this personally, but logically, it's hard to argue with the fact if it's as good at advising people rightly as to the law, it should be as good at judging cases. Now, that is a very superficial analysis, and I can't pretend to have confidence in it, but it may be the case. There are lots of ifs and buts attached to that. There are moral issues, there are public confidence issues as well. But I think it would be a very brave person who would rule out the frightening possibility of artificial intelligence managing to achieve what at the moment is achieved by highly intelligent lawyers and judges, some of whom are highly intelligent.
Yes, at the very back there. You, yes.
Thank you very much for your robust defense of the broad conception of the rule of law. I'm sure it's very appreciated in this hall. You described yourself as an observer of the People's Republic of China system, and from what you were saying, Clearly your views differ from the way the sovereign there acts. And yet, a judicial officer in Hong Kong swears allegiance not only to the basic law of Hong Kong and the Hong Kong SAR, but owes allegiance to the People's Republic of China. Can you explain how you understand that allegiance?
I think that given that my jurisdiction in the Court of Final Appeal only extends to Hong Kong, and when I took the oath it was as a non-permanent judge of the Court of Final Appeal, although you're absolutely right that the oath was to the PRC, in practice it can only be seen on a true construction as applying to the law within Hong Kong. I suspect, although this is pure speculation on my part, that given that obviously it's important and understandably important to Beijing, that the emphasis is that Hong Kong is not a separate country, but is part of the PRC, that it's right that one gives the oath to the country. But nonetheless, as far as I'm concerned, the oath is to administer the law as it is in Hong Kong. And that is how I would answer your question. I must admit that that is an off-the-cuff answer, because the point had not occurred to me till you raised it. But that, I think, is the answer.
Are there questions on this side before we go to questions on that side? Are there questions on this side? We'll go to Professor David Law.
Thank you, Lord Neuberger. You likened yourself to a canary in a coal mine as an indicator of judicial independence, and that the presence of non-permanent justices from abroad on the court is a reassuring indicator that the court remains independent. Another possible response to a judiciary in crisis or a court in crisis would be to say that you could do more good by staying and fighting, as it were, from the inside if the court were to be under threat. Perhaps you could do more good if the court's independence were really in question by remaining rather than leaving. If the independence of the court were really under threat, perhaps that's precisely when you'd be most needed. Perhaps that's precisely when the NPJs would be most needed, and so perhaps that is precisely when you would expect them to stay. Is there anything wrong with taking that perspective, that it would be precisely if the independence of the CFA comes under attack that you would be most needed and the NPJs would be most needed, and you would take the position that that's exactly when you would stay?
I think that's an entirely fair point. I'm happy to stick with the canary analogy, because instead of drooping and dying, we should perhaps sing. And that's what you're saying, we should speak out. I think that's an entirely fair point. I think judges it's not comparable, but judges, for instance, what could come to mind are judges in Nazi Germany. Initially, no doubt, a judge would stay, even if he felt what was happening was wrong, and might speak out. But a point might come when you feel that there's no further point in speaking out and you have to resign. But I think you have an entirely fair point, that it may be right to speak out, rather than just to say, as it were, I'm speaking out and resigning. I'm speaking out and staying. I think that's an entirely fair point. I hope and trust it never comes to that, but if it does, I will bear in mind what you say.
I think we have time for one more question. And yes, now there's a choice between you, the younger person, and the person in the back. I'll go with the person in the back. Yes?
Lord Neuberger, I wanted to ask you about diversity, because while I certainly see the importance of diversity in the judiciary from a democratic and legitimacy point of view, there is a tension, is there not, from a jurisprudential and even practical listing possibility that it shouldn't matter who the judge is. If we are now saying that we need a diverse judiciary for democratic reasons, is it not beginning to open the path of allowing us to distinguish cases on the basis of which judge decided them? That we might say that this case was decided by a woman, and so we need to dismiss it on that basis, or alternatively, it was decided by a pale, stale male, and we need to distinguish it on that basis. I mean, is there not a tension between diversity and perhaps one might say the stability of precedent?
No, I don't think there is. I think the way I see it, we're talking about institutional diversity. I'm not looking at individual judges and individual decisions. I have an open mind, and I didn't say this was the reason for diversity. I'm not convinced, I'm not sure it's wrong, but I'm not convinced by the theory some people have that women or somebody from a different background will decide a case differently from a man or someone from another background. They've all been brought up in the law, and I suspect any difference is more attributable to character than it is to gender or anything else. But I think it's important that if you have a judiciary, the most obvious difference, it's the one you've mentioned, is gender. It's the easiest to deal with, to identify. But if you have a judiciary that is 95% men and the population is 50% men, then statistically, you're unlikely to have the very best people who are judges completely, because it's just as likely a woman's going to be a good judge as a man. So you start off with the proposition that it looks probable that you haven't got all the best judges. Secondly, it suggests something's unfair, unless women don't want to be judges. And if something's unfair, that's something anyone should worry about, but particularly judges or those in the legal profession. And lastly, I think there is a feeling, and it's probably less, I can't speak with authority about Hong Kong on this sort of subtle issue, but certainly in the United Kingdom, which has quite a degree of class about it, and division as well as unity, I think it would reinforce the feelings of women, if they're feeling oppressed, if they see a judiciary which is almost exclusively male. And so I think all those are good factors. But I entirely agree with you that you do not want to be allocating particular cases to particular judges because of their ethnic origins, their gender, their sexuality, or anything like that. That I agree with you is wrong, but I'm trying to look at it institutionally.
I think that concludes today's lecture. There are three things that remain to be done. The first is to thank Lord Neuberger for his lecture today, and perhaps we might give a thunderous round of applause. The second is to thank the Dean, but especially the Vice-Chancellor, for arranging this venue, the Grand Hall, at very short notice this morning in order to accommodate everyone in these comfortable surroundings. So perhaps a small round of applause for the Dean and the Vice-Chancellor. And finally, that on behalf of the Dean, I should apologize to everyone for overrunning for 10 minutes. So perhaps a round of applause for all of us. Thank you very much.
I think that last apology should actually come from me, from probably talking too much.